I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, I am bringing you number 175 on our compilation list. Don't forget to like, comment, share, and subscribe. It is much appreciated. Before I give you the rundown of the 3 judges' courtrooms we will be in, don't forget that there will be commentary left in from these proceedings being previously aired, those that have commentary in them. Also, chapters will be added for your convenience. And now let me give you the rundown on the judges' courtrooms that we will be in on today. First, we will be in the courtroom of Judge E. Lanice Bryant out of the state of Michigan. Second, we will be in the courtroom of Judge William McConical, also out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Charles Hart out of the state of Kansas. Guys, we are climbing the ladder up to number 200. We are heading that way. So keep on supporting, keep on watching. We got a whole lot more videos coming for you. But for now, we're going to jump in to 175.
627-2201. The people of the state of Michigan versus James Matthew Tyers. The defendant is charged with 1 count of disorderly disturbance. And today is the date set for a pretrial conference. Ms. Ritter, your appearance, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Mr. Tyers, your appearance, please.
There is no Mr. Tyers. My name is James Matthew of the family Tyers. This has been established not only in your...
Okay, his name is James Matthews of the Tyers family.
Judge, on several occasions.
Sir, you don't know if I've been communicated with.
Yes, I did, because I have documents. I have certified...
Okay, I'm going to mute you. You don't have anything with my name, with my signature on it. You don't know if I've been communicated with. You may be able to ask me if I've been communicated with, but you don't know if I've been communicated with. So please don't say that I've been communicated with. You may have communicated with the court. You may have communicated with the court clerk. You may have communicated with the court administrator, but you have not communicated with me, nor do you know whether I've received any communication. If you want to indicate that you have sent a document and you want to ask me if I received it, then we can discuss that. However, you don't know what I have received, nor who I've been in communication with. You may proceed.
On the 19th of August, I spoke to you personally in your Zoom court, just as I am doing today, and I gave you the details of the situation. I also told you on the public court record that you'd been served with an affidavit of truth. David was sent to you in August. It was received by the 36th District Court in August. It became judgment and truth in law in September. It was also sent to Christina Ritter. It was also sent to the clerk of the court, who proceeded to send them back first-class mail without any communication. During that communication that I did speak to you regarding this situation, you abandoned ship of the court and refused to address the situation. Since that time, I spoke to Christina Ritter after making 5 attempts to address the situation that should have been remedied a long time ago because of the criminal behavior conducted by 2 police officers, 1 man and 1 woman. Because Christina Ritter decided to put the phone down on me, again, abandoning ship.
And so you call it abandoning ship, and I call it maintaining proper decorum of the courtroom. Ms. Muldrow, do you have the file for Mr. Tyers?
There is no Mr. Tyers, Judge.
Don't interrupt me. I can call you Mr. Tyers if I want to.
Okay, well, I'm just making...
That is the name that appears on the docket. And so as the name appears on the docket, that is how I address all individuals who come before my court. At this particular moment, I am speaking to my court clerk, and I would appreciate if you would not interrupt that communication. Miss Muldrow, can you look in the file and tell me, have I received any filings or anything from regarding this matter?
Judge, I'm looking in the file and there's no motions or anything in here at all.
So, sir, we have not received any motions despite you saying that
I didn't use a motion. I served you with an affidavit of truth, and last Friday, the 7th of January 2022, you were served with a second one that went to you.
I wasn't served with anything because last Friday on January of 22, I was on an airplane to Arizona. So you didn't serve me with anything, sir.
You might have been. It was sent to the 36th District Court, along with one that was sent to Christina Ritter by the prosecutor's office and the 36th District Court, and one was sent to the clerk of the court. I'm not here to argue with you, Judge. I'm not here to argue with you. Can I ask a question?
You may.
What is the colour and age of the man allegedly on the docket?
I could care less about the color or the age of the man. Okay, so here we are. We're not getting anywhere. Ms. Ritter, how do the people wish to proceed with this case? Do you have a complaining witness?
Your Honor, so just a little procedural background on this case. It started out as a felony with count 1, assaulting, resisting, and obstructing a police officer, which was dismissed at the exam stage, leaving count 2, disturbing the peace, left for this matter, which is the misdemeanor count in front of Your Honor. So at this time, the people are ready to proceed on disturbing the peace charge, Judge.
All right.
As the people's understanding that there's no complaining witness needed for that disturbing the peace charge.
The court is going to enter a not guilty plea on behalf of Mr. Tyers. Now, if Mr. Tyers if there is no Mr. Tyers, then I would appreciate this other person not showing up for court. So if you're not Mr. Tyers, please don't come back to my courtroom because the only person that I'm interested in is Mr. Tyers. I don't know what his color is, and it is of no consequences to me. I don't know what his age is, and that is of no consequences to me. I don't know what his race is, and that is of no consequences to me. What I know is this. If you're not Mr. Tyers, just don't show up. I want to just deal with Mr. Tyers. That's the only person that this case is against. And if that is not you, then perhaps it's someone else. All right. So as it relates to Mr. Tyers, apparently he didn't show up. Mr. Tyers hasn't shown up today. And therefore, I'm going to just save this case to the end of the docket, as I do with all the other failure to appears, and I will address Mr. Tyers' case at the end of the docket as a failure to appear. Mr. James Matthew, have a nice day. You never have to come back because you're not Mr. Tyers. So I appreciate you. I don't know on his behalf, I guess. I really don't know. You can file a motion with the court. However, I'm not going to entertain anything else. And you are yelling at me at this moment. And so I won't entertain you. So thank you so much. You have a great day and stay safe. All right.
Sir.
Colonel Michael McQuarrie, appearing in appropriate persona.
All right. To my understanding, sir, you filed a motion to have Judge Bryant disqualified from the case. Judge Bryant denied your motion, and essentially your motion was appealed up to the chief judge, which is me. Is that correct, sir?
That's correct.
Okay. Argument.
Well, the argument is, sir, under Michigan Code of Judicial Conduct, the judge is in violation of Canon 1 and 2 because I'm here falsely accused for a 21-year-old warrant. And I try to speak, and she acts like Judge Judy. She just constantly cuts you off, is threatening, so far as be quiet. Like, I mean, Canon 2, it says public confidence in the judiciary is eroded by irresponsible and improper conduct by judges. A judge must avoid all impropriety an appearance of impropriety. A judge must expect to be the subject of constant public scrutiny. A judge must therefore accept restrictions on conduct that might be viewed as burdensome by the ordinary citizen and should do so freely and willingly, Judge. And I come into court very respectful. I'm a 51-year-old man and I respect the system. But I'm feeling that I'm being given, disrespect. I'm being silenced. I mean, I have a right under the free speech to petition the court for redress of grievances and things of that nature. And if you look at the TV show Judge Judy, this is how she acts, Judge. Totally wrong. And she asked me, what did I want to do with the case? I said, I would like to challenge jurisdiction because I went to prison in 2002 for 15 years and 8 months. They had under the rule, I believe for misdemeanors, 40-something days, for felonies is 6 months. So I request that the prosecutor prove its authority in bringing these charges so late. And I have been home 6.5 years, productive in the community, no problems. And I'm trying to do right, Judge. I made past mistakes when I was a young man. And I'm just being treated like I'm just a criminal. I'm supposed to be innocent until proven guilty, right? So I'm not trying to disrupt this court. I'm not trying to cause you guys hardships or anything, things of that nature. And my due process is being violated, Judge. That's all. I want to just get this case so it wouldn't be left alone. I'm a grandfather. I have children. And their DPD has retaliated against me, Judge. And I know this is a Detroit police court. And I would like an investigation as to things that's been going on by the prosecutor's office, because Kim Worthy and her subordinates are retaliating against me. There's actual proof. At this point, I don't know if you're familiar with Bill Proctor. He's representing me in this matter and another matter so far as investigations for years of, hardships and tyranny committed against me by the system here in Wayne County. So this is all I want, a fair shake judge, a judge who's going to give me due process and give me what I'm entitled to according to law. And that's it, sir.
Okay. Ms. Ritter, would you like to respond in any way?
Judge, the only response that people have is that this is a case from 2002. It's a misdemeanor assault and battery case. Judge, from my recollection of the prior hearing with Judge Bryant, I do believe, if I'm not mistaken, that it was an arraignment process. And as the court was trying to proceed with the process, I do remember Mr. McCreary interrupting the judge while she was trying to make the record. But the people have not gotten to the point where, because Mr. Carnell was disruptive during the proceedings, the people didn't get to the point where there was another pretrial date set where the people could actually see if we're able to move forward on this 2002 case, Judge.
I have a rebuttal.
Yes.
Okay, Judge, I would like you, if it's possible, I know you guys are on Zoom, so you should have access to recordings of these hearings and things of that nature. I believe that the prosecutor just fabricated facts to you because I was not rude to this lady. All I asked her is, she said, what do you want to be done with this case? I said, I would like to challenge jurisdiction. And Michigan and federal law requires once jurisdiction is challenged, it must be proven. How is it that the prosecutor knows statute of limitations? They're licensed. I'm not licensed. I've studied for years in prison. And they don't know that there's a statute of limitations. This is vindictive prosecution because of my complaints against Kim Worthy, Your Honor. And the record will reflect the evidence. And I object to her statements.
All right. Court having had a chance to hear the arguments of the moving party, as well as the arguments of the prosecutor. The moving party is asking for a recusal or to have Judge Bryant disqualified based on Michigan Canons 1 and 2, based on that she is biased, as well as is not allowing a person to be able to basically argue their case. The moving party is stating that he wants to challenge jurisdiction and that he was not allowed to do so. The prosecutor is stating that there was only a proceeding at an arraignment and that the prosecution hasn't even got to the point where they have established whether they want to move forward with the case, but that was not allowed to happen because in their view, there was disruption in the court and there was a breakdown. The moving party is disputing that. He's saying that you can even go, that I could go to the video or the tapes to dispute that. At this time, the court is not going to make a decision at this point. I am going to pull the tape, pull the transcript. I'm going to make a decision very quickly on this. I'm not going to let this continue. And even based on, the court does have an opinion probably on the likelihood of prosecution on a 21-year-old case. So we're going to come back on, we're going to come back on July 6th at 10 a.m. Please check your schedule, sir.
May I also, you say July 6th, sir?
Yeah.
Okay.
Yes.
May I also, if I may,
check your schedule first. Check your schedule to see are you available for that time.
I'm available. I'm stuck here on tether, sir. I'm available at any time you guys want me to.
Okay. All right. Well, put it on your schedule for 10 o'clock on July 6th.
Okay. Can I say one more thing? If you look at Crampton versus Michigan Department of State 395, Michigan 347 at 351, it says the United States Supreme Court disqualified judges and decision makers without a showing of actual bias in situations where experience teaches that the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. And I'm not saying like trying to attack Judge Bryant or whatever else, but she has an attitude like Judge Judy. She just cuts you off. And I'm just like, so when she kept doing it, this is when I objected and asked her to recuse herself.
And sir, and again, as the chief judge, I don't have to have a showing of actual bias, but perceived bias, something in the fairness of justice. That is my stand.
Next case, State of Kansas versus Sydney Taylor Lesley, 25 CR 250. Good afternoon, Miss Lesley. Miss Lesley, you're charged by way of information on or about May 21, 2025 in Butler County, Kansas, with interference with law enforcement, a Class A non-person misdemeanor. Count 2, same date and location, no proof of insurance, a Class B non-person misdemeanor. Same date and location. Count 3, no driver's license in possession, an unclassified non-person misdemeanor. Then count 4, same date and location, failure to register vehicle, and unclassified non-person misdemeanor. And Miss Lesley, do you understand the charges pending against you?
I comprehend the alleged charges against me.
Thank you, Miss Lesley. Miss Lesley, you do have the right to counsel if you cannot afford an attorney.
Excuse me. I was going to say that I comprehend the certain statutory allegations that have been made against me, but I cannot and do not admit to understanding or accepting the jurisdiction of this court over my person or the subject matter absent proof of corpus delicti and a verified complainant from an injured party. To do so would constitute a waiver of fundamental rights, which I explicitly refuse to waive pursuant to KSA subsection 60-212 in the doctrine of special appearance recognized in Kansas jurisprudence.
Okay. You do have the right to counsel if you cannot afford an attorney. One would be appointed to represent you. And Miss Lesley, are you currently employed?
For the record, Your Honor, just to start from the beginning, I, Sydney Taylor Lesley, appearing specially and not generally in propria persona, sui juris, as a living woman and not as a legal fiction or corporate entity. I reserve all rights without prejudice pursuant to KSA subsection 84-1-308 and UCC 1-308. Let the record reflect that my appearance today is under explicit protest and duress and solely for the purpose of challenging jurisdiction and preserving my unalienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And Your Honor, before these proceedings advance further, I must respectfully challenge this court's jurisdiction in toto and move for immediate dismissal of all charges, I hereby invoke the burden shifting doctrine established in State v. Shepard in 2009 and State v. Seams in 2004, which places the affirmative burden upon the prosecution to establish by sworn non-hearsay allegations within the four corners of a valid charging instrument that every element of the alleged offense and my commission thereof has been properly established. The threshold matter of jurisdiction must be adjudicated prior to any other proceedings. As articulated in Ex parte Young in 1908 and recognized by the Kansas Supreme Court, jurisdiction is the fundamental prerequisite to all jurisdictional proceedings. The legal maxim ex injuria just non autora, law does not arise from injustice, applies to these proceedings in their entirety.
Okay, and the court finds that Miss Lesley is appearing as a sovereign citizen before the court, and the court once again.
I object to any of that derogatory. It's very biased. I move for immediate dismissal on those grounds and disqualification.
Court overrules the motion for dismissal of the case. Court overrules dismissal of the
prejudice
case.
And
the court will find that Miss Lesley, that the court does find it has jurisdiction to proceed, and subsequently the court sets your next appearance
You called me
date.
a sovereign citizen. I object. You called me a sovereign citizen.
Yes, ma'am.
That is prejudice and bias.
No prejudice or bias is asserted as to yourself. However, the court, as opposed to trying to write down docket notes to that effect, is just recognizing what you are advising the court, that the court has no jurisdiction over you, and based on your statement made to the court. Subsequently, the court does find you've posted a $3,000 cash bond. $3,000 cash bond has been made. Court does accept the same, and the court does schedule this matter next before Judge Webster on Monday, August 11, 2025 at 9 a.m. Monday, August 11, 2025, 9 a.m. before Judge Webster. Once again, Monday, August 11, 2025, 9 a.m. before Judge Webster. You do need to participate by Zoom process at that point. Subsequently, the court finds that Miss Lesley has not requested court-appointed counsel. Court does not appoint counsel at this point. The court does find that she has posted bond in the amount of $3,000 cash, $3,000 cash bond, and the court has scheduled her next appearance date before Judge Webster on Monday, August 11, 2025 at 9 a.m. Any other matters to come before the court, Mr. Sweeney?
No, Your Honor.
And Miss Lesley?
Your Honor, my jurisdictional challenge is predicated upon multiple independent grounds, each sufficient to warrant dismissal. First, I challenge personal jurisdiction pursuant to Kansas Rule of Civil Procedure. I appear specially, not generally, and have not consented to this court's jurisdiction. The record before this court is devoid of evidence establishing proper jurisdiction over my person as a living woman rather than a legal fiction or corporate entity, as distinguished in Hale v. Hinkle in 1906, and recognizing Kansas jurisprudence. Second, I challenge subject matter jurisdiction pursuant to Kansas Rule of Civil Procedure 60-212, B1. No verified complainant from any injured party has been filed as required by KSA subsection 22-2301 in Butler County Local Rule 3.1. The perpetrated charges arise from actions of agents of the state acting under a color of law, not from a legitimate controversy between adversarial parties withstanding as required by Article 3 jurisprudence jurisprudential principles adopted by Kansas courts in State ex rel. Morrison versus Celebius. Third, I challenge territorial jurisdiction. The alleged incident occurred after I had ceased operating my conveyance and was exercising my unalienable right to travel, placing it outside the territorial jurisdiction of traffic enforcement under KSA subsection 8-244, which by its plain language applies only to licensees who have voluntarily entered the regulatory framework. Fourth, the prosecution cannot establish the corpus delicti of the alleged offenses. As held by the Kansas Supreme Court in State v. Stern, in 2015, the corpus delicti rule serves as a safeguard against convictions based on false confessions or statements. One cannot interfere with a peace officer absent of officer's lawful execution of duties. Where the initial detention was unlawful, as it was here due to lack of probable cause, there can be no derivative crime or of interference. Fifth, the refusal to provide identification is not a crime in Kansas, absent specific statutory circumstances not present here today. This is in support by Brown versus Texas in 1979. The Supreme Court held that detaining a person solely to obtain identification violates the Fourth Amendment absent reasonable suspicion of criminal activity. The principle has been recognized and applied by Kansas courts. In one moment, please, while I gather another statement. Okay, and another thing is, and this is, may it please the court, for the record, I must now enter an oral objection and motion for disqualification of the presiding judicial officer pursuant to Kansas Rule 2.11 of the Code of Judicial Conduct, as well as controlling principles under the Due Process Clause of the 14th Amendment. During a prior proceeding, specifically, that's proceeding, specifically, this court referred to me by the term sovereign citizen, a pejorative classification which carries with its government manufactured implications of extremism, frivolous, and legal irrelevance. This label, unprovoked and unsupported by any factual predicate, constitutes a stigmatizing judicial characterization that violates my right to a neutral and detached tribunal. The use of that term demonstrates either a prejudiced bias or a judicial predisposition toward delegating the substance of my legal posture. As the Kansas Supreme Court has held, even the appearance of partially mandates recusal, and here the record reflects actual prejudice in open court. Wherefore, I respectfully move this honorable court to dismiss all charges with prejudice for lack of jurisdiction, issue a finding that the prosecution has failed to meet its burden of establishing jurisdiction, order the immediate return of all my property seized, including the 251 USD, confiscated and converted to a reloadable Visa card without my consent, order the expungement and permanent sealing of every associated record pursuant to KSA subsection 22-2410, award compensation for the full measure of damages sustained, including costs for my automobile window repair, bail costs, and compensation for unlawful detention and deprivation of liberty, grant such and other and further relief as this court deems just and proper. The breaking of my automobile window without warrant or probable cause of a search and confiscation of my currency constitutes violations of clearly established rights for which the law provides remedies pursuant to the maxim ubi jus ibi ridiem, where there is a right, there is a remedy. I reserve all rights without prejudice, waive none, and maintain my special appearance for the sole purpose of challenging jurisdiction and preserving my alienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And thank you for hearing me. I do appreciate you, Your Honor, and thank you for your time.
And once again, matter is set before Judge Webster on Monday, August 11, 2025, 9 a.m. by Zoom. There being nothing further to come before the court is in recess, and have a good day, Miss Lesley.
Thank you, Your Honor.
And Mr. Sweeney, that's the last case I show on the first appearance docket.
Thank you, Your Honor.
Have a good day.
You too.
Well, guys, we have come to the end of this proceeding. And listen, Miss Sydney Lesley definitely had a whole lot to say. As you guys like to call it, a word salad. It was definitely a lot of word salad in there. She definitely got super offended when Judge Hart called her a sovereign citizen. And I don't know if you guys noticed, I've seen defendants, get offended because they've been called a sovereign citizen in the past, right? But I've never seen someone already have a script prepared to address if they've been called a sovereign citizen. I've never seen that before as long as I've been covering these videos. Maybe you guys have. If you have, put it down in the description. But it was almost like she was anticipating Judge Hart calling her a sovereign citizen. But as we can see, after that third rant, everybody just pretty much kind of just zoned out. Judge Hart let her say whatever she needed to say, get everything that she needed to get on the record. She definitely had her super, super duper sovereign citizen head on. And obviously you can tell she's just now getting into the script game just by the way she was reading. And another thing, and I'm going to say this last thing, this will be my last thing. I don't know if you guys noticed, but I believe it was when she went on that second rant. You can go back and check it. It was either after the first rant or the second rant. She kind of like leaned back with a smile on her face and just let out a big sigh as to say, look, I did it, almost as if she had, overcome some great fear, and accomplished some big goal. That was kind of weird. So it kind of showed that, this is her first time or, doing this. And not only that, but that she got this from somebody and that she had it all laid out perfectly right in front of her and read it line by line, precept upon precept, like she was not playing. But, we'll see her very soon in front of Judge Webster. That's going to be definitely very interesting because I can see Judge Webster, ma'am, and doing this, Judge Webster, that's her favorite thing. But yeah, it's going to be interesting. But with that being said, once again, shout out to Sovereign Citizen Chronicles for providing me with this footage. I definitely appreciate it. Thank you, sir, once again. And with that being said, guys, this is Sovereign Citizens Hall of Fame. Don't forget to like, share, subscribe, all of that. And for now, guys, Sovereign Citizens Court is adjourned. Thank you, guys, and God bless.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.